Okay, ladies and gentlemen, we're going to get started. So if we still have some seats up front here, so we can get some people from the back room. There's still plenty of seats there. So if you're back there by the food, unless you're still eating or unless you want to stay there, and you can do that too. We have it on simulcast, I guess, or something over there, but please come forward and take a seat. Okay? All right. Ladies and gentlemen, thank you for attending the Cardinal Management Group 2013 client event, which we are calling the Changing Legal Landscape this year. The past several years have brought unique challenges to the community association industry. As you know, our industry continues to become more complicated by virtue of the many diverse situations that are faced by our boards of directors and the management and legal professionals that represent them. From assessment collections to rules enforcement, from constant changes in legislation to increased regulations, these are challenging and, in our opinion, difficult times. Nowhere are those challenges more evident than in the areas of laws and regulations that govern our industry. It is with this in mind that we thought it would be appropriate this year to have the event focus on the legal landscape in the Commonwealth. But first, please allow me a few preliminaries before we get started. My name is Thomas Mazie, and I'm the CEO of Cardinal Management Group, and I'd like to introduce our executive team. If they could stand up when I announce them. My partners, Don Mazie, our Chief Operating Officer, Patrick Mazie in the back, Chief Human Resource Officer, Darrell Paynes, our CFO, Darrell, Jonathan Suker, our Vice President, Shirley Classic, Vice President for Business Development, Grady Carlson, who's our in-house legal counsel, Melissa Winter, our Director of Corporate Administration, Jessica York, Assistant Vice President of Accounting, and Terry McGuire, Vice President, who could not be here this evening because he's attending a meeting in Maryland. I'd like to thank our many managers and other staff members that are here in attendance. Having been in this game for a lot of years, I can tell you that an evening without a board meeting is a precious period of time. So I appreciate the time that they took out to be here. Not that they had much of a choice, mind you. Special thank you to our Fairfax office, in particular Brian Cramp, for putting the logistics of this program on for this evening. I'd also like to thank our host community, the Penderbrook Community Association, that has this beautiful facility and that we have proudly managed and been associated with for 23 years. Ladies and gentlemen, I am not an attorney, although I do play one on television. Considering the topic tonight, however, we thought it best to assemble some people that are in the best position in our minds to give you guys some insight as to what's happening out there right now and what it means to us as practitioners in this crazy business that we call community management. So let me introduce our panel to you, beginning here on my left and your right. Juan Cardenas is a principal of Reesbroom PC. Mr. Cardenas has specialized in the representation of condominiums and HOAs for over 25 years, specializing in areas such as community governance, training of board members, negotiating and drafting contracts, construction defects and claims, and conversion and turnover issues. He graduated with honors from Georgetown University and is published in the Harvard Journal of Law and Public Policy Studies. That's pretty cool. His organization represents over 300. See, it's gonna, yeah, there we go. So it begins. Yeah, that's right. His organization represents over 300 clients in the Washington, D.C. metropolitan area. Bob Diamond, is a principal of the law firm Reed Smith. Mr. Diamond has practiced real property law in the Washington area for 38 years. He has been a dedicated volunteer of the Community Associations Institute, including serving as president of both the Washington chapter and the national organization. Mr. Diamond's emphasis has been on preparing documents for community associations of all types, negotiating warranty and construction defects, representing community associations, and litigating association-related issues in both state and federal courts. He also serves on the faculty of the Community Association Law Seminar and the Professional Management Development Program. Lori Dulson. Lori's right here. Lori is the principal of the law offices of Lori L. Dolson. Her practice is in Fairfax, Virginia, where she has practiced exclusively in the area of community association law for over 30 years. Ms. Dolson has been a longtime member of the Community Association Institute, has written and lectured on various topics related to community association law for both attorneys and for non-attorneys. She served in the House of Delegates of the American Bar Association and the governing body of the Virginia State Bar, and is past president of the Fairfax Bar Association. She's currently a member of the Fairfax Law Foundation, the board. We also have this evening Bill Marr, is the principal of the law office of William A. Marr. His office are also located in Fairfax, where he has been representing community association and small businesses for over 35 years, focusing on civil law, business law, real property matters, and civil litigation. Bill is a business partner of the Community Associations Institute and serves as the chairman of the CAI Virginia Legislative Committee and vice chairman of the Virginia Legislative Action Committee. We also have with us this evening William B. Mason. Bill Mason is a principal of Segan, Mason & Mason. Bill's offices are in Annandale, Virginia, where he is concentrated in the areas of community association law and real estate transactional law since 1986. He is a frequent writer and speaker on community association issues and has received several awards from CAI, including the Public Advocate Award and the Hall of Fame Award. Bill has chaired the Virginia Legislative Committee and CAI's Virginia Legislative Action Committee, and is also a member of CAI's College of Community Association Attorneys. Andrew J. Terrell, I knew I was going to screw that up. You know, McGuire has pounded me about that this week. Drew has been representing, I know it's the Klan, representing community associations in Virginia and Washington, D.C. for over 20 years in the areas of litigation, covenants enforcement, collections, governing document interpretation, and insurance. Drew is a frequent contributor of articles as well as a regular speaker for the Community Association Institute. He is the co-section head of Whiteford, Taylor, and Preston's Community Association section, as well as the managing partner of the Falls Church office. We also have Lucia Anna Giugiani, affectionately known as Pia, who is the founding partner of the law firm of Mercer Trajani. The practice is located in Alexandria, and Ms. Trajani has been in private practice since 1987. She's been involved in many organizations, including the Virginia Real Estate Board, the Board of Governors of the Virginia Bar Association, and the Common Interest Community Board, where she currently serves as the board chair of that body. She's been involved with the Washington Metropolitan Chapter of CAI since 2000, receiving many awards and distinctions from that organization, and serving as a charter fellow of their College of Community Association Lawyers. We also have this evening Alan Warren. Alan is a principal of the law firm of Chadwick, Washington, Moriarty, Elmore, and Bunn. Alan is an attorney in the Chadwick's Fairfax office and represents community associations in both Virginia and in D.C. From 2006 to 2012, Alan served on the board for the Washington Metropolitan Chapter CAI and also as president in 2011. He's also been a member of the Virginia Legislative Committee since 2004 and has spoken at numerous programs regarding community association law. So there you have the panel. I can't recall having seen so much legal talent assembled in one room, all working for free. So please take advantage. I have to say that it's a good thing that the IRS is otherwise engaged tonight, because if I had to declare the in-kind value of these services tonight, Cardinal might go broke. Tonight's format is going to be a question and answer session. We have requested questions from you in writing, and many of you have done that, and we'll also be taking questions from the floor as time permits. We have a lot of ground to cover in the next 90 minutes or so, and so I ask that our questioners be concise and that our panelists be as succinct as lawyerly possible. I meant humanly possible. While all topics are open this evening and on the floor, I wanted to start with a few cases that we believe are particularly germane to tonight's discussion. Allow me a few moments to go through these, and we will begin questions afterwards. I'm sure many of you have heard about these cases, but tonight you're going to have the opportunity to hear directly from those who were involved, as well as these legal experts that may have their own take on what these various decisions mean. It reminds me a little bit of the song from the former Beatle, George Harrison, the Sue Me, Sue You Blues. You bring your lawyer, I'll bring mine, we get together and have a bad time. So, here we go. The first case I'm going to mention is the Manchester Oaks case, Manchester Oaks Homeowners Association versus BAT. So please bear with me for just a few minutes. In this case, the board adopted a parking policy which townhomes without a garage were assigned 2 spaces. Townhomes with garages were assigned no parking spaces. The declaration provided that every owner has a right and easement of enjoyment in and to the common areas. The declaration also stated that the association had the right to establish rules and regulations governing the use of the common areas, including the right to designate a maximum of 2 spaces in the common area. And nothing required the association to make designations to ensure parking spaces were available for use by any particular owner. Owners of garage townhomes challenged the preferential assignment of these parking spaces to homes without garages. The Fairfax County Circuit Court found that the parking policy was invalid because it did not assign spaces equally to all owners. The association appealed to the Virginia Supreme Court, and the court determined that equality is inherent in the definition of the common area. The court went on to say that the association must assign spaces to all owners equally unless the declaration expressly provides otherwise. The court concluded that the parking policy was invalid. The court also upheld an award of attorney's fees in the amount of $188,841 to the owners based on the prevailing party language that exists in the Property Owners Association Act. From our take, from the industry standpoint, we see this case as a loss in that it limits associations to a strict interpretation of the governing documents. It also means that an association may be held responsible for attorney's fees incurred by an owner who initiates legal action against the association if the owner prevails. The next case I'd like to mention is Old Bellhaven, Samir R. Farhan et al. Versus Old Bellhaven Town Owners Association. An owner challenged the association's authority to impose violation charges. The Fairfax County Circuit Court determined that the recorded declaration of a homeowners association creates a contract between the association and its members. If a provision is not included in the contract, it is excluded. Therefore, unless the declaration expressly provides for charges as an enforcement option, or it expressly allows the adoption of rules and regulations imposing such charges, charges will not be available to the association to use in enforcing violations of its recorded documents. The court concluded that nothing in the Act gives the association the authority to exceed the power granted in its governing documents. Our takeaway from this, from an industry standpoint, is that this is also a loss, as it limits the associations to express terms in their recorded governing documents. If an association wishes to impose charges and does not have express authority in its recorded documents to do so, an amendment is necessary. A policy resolution is not sufficient. The next case is Lee's Crossing versus Zenome. The association filed a suit in Loudoun County Circuit Court and asked the court to enter a judgment for charges pursuant to the Property Owners Association Act. The board based the charges on a policy resolution authorizing the association to assess charges for violations of the declaration or rules and regulations, as there was no express authority for violation charges in the recorded governing documents. The court determined that the plain language of the statute allows an association to authorize charges in either the declaration or the rules and regulations. The court took note of the Fairfax County Circuit Court's decision in Farhan versus Old Bellhaven, in which the court determined that the authority to assess charges under the Act is limited to situations where the declaration expressly allows for such charges. Our takeaway on this case is that the Loudoun County Circuit Court appears to have taken a different position from Fairfax and has allowed, in this circumstance, an association to assess charges on a policy resolution when there is no express authority in the recorded documents. From our perspective, this is a win. And then the last of the cases is Shadowwood Condominium Association versus Fairfax County Redevelopment and Housing Authority. The Fairfax County Redevelopment and Housing Authority filed suit against an association in Fairfax Circuit Court challenging the authority to assess charges for rules violations. On motion for summary judgment, the Circuit Court ruled in favor of the county. The association appealed to the Virginia Supreme Court. The court found that there was no reversible error and upheld the Circuit Court's decision. The association has a unique provision in its master deed that stated no common expenses other than sums shall be assessed other than for the maintenance, repair, replacement, or improvement of the general common elements. Based on this language, the court determined the association has no authority to assess charges for rule violations. The court emphasized that the statute authorizes an association to assess charges for a rule violation to the extent that the condominium instruments or rules duly adopted pursuant thereto expressly so provide. By its plain terms, the statute is permissive in nature. It does not confer authority to an association beyond what is in the association's governing documents. And our takeaway on this one is that the case affirms the decision in Old Bellhaven that associations cannot assess charges unless specifically allowed for in the recorded governing documents. So that is, and again, as I said in my opening comments, that is not, I am not an attorney, but that's our take on these cases, and it was called together with information that I got from some of the attorneys sitting at the table. Before we go to the question and answer portion of our program, I thought it would be appropriate, because there are representatives of the law firms that were involved in all of these cases, to give them an opportunity to comment or otherwise add onto what I had just stated. So I'm going to start with Drew. And Drew, if I accurately summarize Manchester Oaks, is there anything that you'd like to add about that particular case?
Certainly a nice day. I think you did a very good job of summarizing Manchester Oaks. There's a couple of points that have to be made. The most essential point is that the court, Justice Minska, the opinion, made it abundantly clear that it isn't in your governing documents. If you don't have a provision in an HOA where it specifically gives the board of directors the right to segregate the parking spaces, you can't do it. Sully Station and White versus Boundary were a little bit vaguer, and they talked about licenses and things of that nature. I think they've named now the key thing is the term common area is considered equal, and that's what the court said. The other thing, there is one issue that I think we can turn on its head with regards to Manchester Oaks, and that is the court really reduced the compensable damages to these plaintiffs to virtually nothing, yet it awarded a sizable amount of attorney's fees. I think the same argument can be made for the associations. What's good for the goose is good for the ganders. And we all board members here and all managers know that in many instances in collection cases where the unit owner has put you through the paces and you end up with a large fee and then you get in front of a judge and the judge goes, oh my God, look at the large fee. Like these judges never billed any time before they went on the bench. Oh. Yeah, well, that's true. That's true, and it shows. And so you can say, look, judge, it doesn't, the quantity, the number that is in the judgment does not necessarily equate to the amount of time that has to be expended in achieving that judgment. So I think we can take that portion of Manchester Oaks, because Tom, I think you're right, it's an L. There's no question about it. But I think we can turn that part of it into somewhat of a W. Okay, great. If you'll pass the microphone to your right, I'm going to let Pia talk a little bit about Old Bellhaven, if you would.
Yeah, definitely a loss. I will tell you that the reporting on that case was covered in the Washington Post and also in the most recent issue of Common Ground is inaccurate. You should know that. I think it appears that the homeowners were embattled. They were not. In this case, the association had adopted a due process policy, much as we've been doing for a number of years. It's been our recommendation to all of our clients. I don't think there's anyone at the table who would disagree with that. The association had not even implemented the policy. They had never imposed a charge, had never taken any owner in front of a due process hearing or assessed a charge, had not even done that. And the owner wanted not just that the association, that the court say that the due process procedure was invalid, but also they wanted a deck and they wanted a roof. This is a townhome community right off of of Bellhaven Road, right across from the country club in eastern Fairfax County, just off the parkway. These are townhomes, so they're right on top of each other, literally, and they were never designed to have decks. The roof line, they were trying to keep them the same. The association was willing to say, okay, you want a different roof material, fine. In fact, we will rescind the policy on due process. We won't impose it. But the homeowner pressed. The homeowner would not settle. The homeowner wanted a deck. Okay, that's the story. And from that, we went to Fairfax Court and fought on the issue of their authority to impose a due process procedure. We think the court's wrong. I think the Supreme Court's wrong. I think that what we are learning, and these series of cases this year is that the Supreme Court sees it differently. They want express authority in the governing documents, the recorded governing documents. For a homeowners association, that's the declaration. For a condominium, it's either the declaration or the bylaws, more typically the bylaws. So, and that's what we're learning. So, I don't think it's not been a good year. 2012 was not a good year for homeowners associations and condominium unit owners associations in the courts.
Okay. If you'll hold for just a moment as we get through the 4 cases, and then we'll get some questions. Bill, with respect to Shadowwood, anything to add?
I think you did a good job of describing it. I just would add a couple things. We're sitting here on the 1-year anniversary of the argument in front of the Virginia Supreme Court of Shadowwood.
Really?
An auspicious day. Yeah. And I think one of the things to mention is that Shadowwood was a condominium case. Shadowwood was formed under the Horizontal Property Act, had a very old master deed, and had the provision you mentioned about what common element expenses or common expenses could be for, and that's what the court kind of hung its hat on. The case was brought by Fairfax County Redevelopment and Housing. They had about 16 units in Shadowwood, and there were a number of issues with the units and occupants and leases and so forth. So the association had a due process resolution that it had adopted, like many other communities, pursuant to the provisions of the Condominium Act, the same provision that's basically in the Property Owners Association Act, and use that provision to assess charges, enforce rules and regulations, that sort of thing. After the old Bellhaven case had been decided, the Shadowwood case was brought, and it was brought by the Fairfax County Attorney's Office. After the Shadowwood case was over, I had a chance to talk with the Fairfax County Attorney's Office, and they felt that they could bring the Shadowwood case because of the decision in the old Bellhaven case, and they did. After the case had been decided on the circuit court level, we felt that it was important to go ahead and appeal it up. There were a lot of other issues in the case. Initially, about 7 or 8 board members had been sued individually. We got them out of the case, and we narrowed the issue down to whether or not the condominium association could rely on the provisions of the Condominium Act to go ahead and enforce rules and regulations, and that was the issue in the case. There were other issues which ended up not being terribly important. At any rate, so we lost at the circuit court level, appealed it, and it was pretty clear from the oral argument at the Virginia Supreme Court level that they were very strictly looking at what the contents of the declaration or master deed was, and the fact that you may have some additional language or other language was not language that you could use if the language was narrowly construed in the master deed and there was not that additional authority. So I think that's where we are. Many of the lawyers here said they look at the language in the instruments or rules and regulations and say, well, if we adopt a due process resolution, we're good to go. That's not the way, and that's not the game. So we're looking forward to comments and discussion about it, but that's where we are.
Okay, thank you. Sir, did you have a question directly to these cases, or because we have a bunch of written ones here?
Are you able to go back and amend the bylaws after one of these cases, not going after the individual that brought the case of the original instance? Are you able to amend the bylaws?
Yeah, well, I'm not the attorney, but I can tell you yes, and I think what the council is going to be telling you is that in order to pursue various remedies, you're going to have to change your bylaws that will give you, or your declaration that will give you the express authority that the courts seem to be wanting. Yes.
When you say bylaws, it's got to be your recording.
Right, the recorded documents, right. Hold on, so we've got some questions that are on point, which I want to run through, and I think we'll end up addressing a bunch of this kind of stuff. So, and what I've done from the questions we've got, I'm going to try to make sure everyone gets an opportunity to comment, okay? So, the first question I'm going to give to Juan. The question reads, if the association does not have specific authority in our documents to assess charges for violations of the covenants, what is the point of having due process hearings at all? My understanding is that most of the law firms in the area now will not sue to collect these assessments. Is filing for an injunction the only way to enforce covenants absent the specific authority? And then lastly, is the association's ability to withhold privileges such as parking, pool passes, and access to amenities affected in any way by these recent rulings?
I think what we're hearing again and again from the judiciary is that you have to have the authority expressed in the recorded legal documentation of the association. If you're going to effectuate some form of penalty, some form of sanction, you're going to have that authority expressed in your legal documents.
So does that extend though to the parking and the pool passes and all that kind of stuff? I mean, what's the take there?
I think it does, and I think it's a high-risk maneuver to rely upon other forms of authority like resolutions, courses of dealing. We're getting a pretty consistent line of case law from this particular Supreme Court, and it's permeating on down to the Fairfax County Circuit Court, where most of our community associations are located. If you're going into court with a contrary theory, you better
be loaded for bear, huh?
Yeah, and the other thing that we didn't get to about the cases of Manchester Oaks and Old Bellhaven is that those two community associations had to file for bankruptcy relief in the aftermath of those adverse rulings. The legal fees awarded to the prevailing parties were so high, community association didn't have the ability to pay those judgments, and they had to file for bankruptcy relief. You can imagine the kind of carnage that created with the resale market. So somehow, some way, the lawyers in this room, the property managers, and all of you are going to have to figure out how to avoid some of these high-risk, highly expensive lawsuits. Because if you don't win, the results can be calamitous for the association.
I would just add, in Old Bellhaven, they tried to avoid litigation.
Right.
They
That was
made
clear.
every effort. And there are limitations in their documents on the ability to assess. So they could not even assess because it had to go to a vote of the membership to pay the legal fees. So there's not just one Swift, quick answer. It's as Juan's described, you've got to go back to the express authority. But I want to make sure that folks know that board at Old Bellhaven tried to resolve it. They gave 2 out of 3 issues, gave up on 2 out of 3 issues to that homeowner, and he pressed.
But if I understand Juan correctly, what the issue that we have to confront, especially if you take a look at Shadowwood. Shadowwood is a very unique case because number one, it's not even published, which means it doesn't have any value to the future.
Except for scares all to death.
It scares, one of the reasons it scares us all to death is because I was actually on a case that was unpublished that I won in the Supreme Court. I had 2 that session. I was there when Bill argued. And there's no question in my mind that if a case came down the pike and you wanted to test the waters, that Supreme Court is ready to bear. And what will happen is exactly what I think the point that Juan is making, which is which association is willing to roll the bones, and then if they lose, and that 4 out of the 7 say, no, what we meant in Shadowwood, what we meant in Shadowwood is actually what we meant, you're going to spend $180,000, and you're going to face that. And none of us up here are going to have our clients take that risk.
So you're at the mercy of someone who wants a deck? I mean, that's the issue. They backed all the due process.
And as this questioner indicates, then what is the point of having due process hearings? As practitioners, we're property managers. Our clients look to us to resolve issues. You know, the deck, the this, the that. Let's bring them in front of a hearing. What's the point?
I don't think you can have them anymore unless you are, for example, a community that has in your declaration specific language such as if someone doesn't pay, you can revoke their right to use recreational facilities.
Right.
I think, it may not be the full meaning of 55-513 or the Condo Act comparable provision, but I think if you already have something in your documents, you probably can then use the due process procedures, or certainly if you amend your documents to provide for the necessary authority, and then you use the due process procedures.
Okay. The next question is going to go to Bob Diamond. As an attorney representing a client in a lawsuit, what advice do you typically give a board of directors prior to this engagement? Does your firm have an internal formula that is used in light of present circumstances or in when evaluating the upside or downside of risks of court actions?
Well, that's somewhat of a general question. We always advise clients, developers, associations, or individual homeowners that they'd better make sure that the issue is important enough to be able or willing to spend large amounts of money, because once you initiate litigation, it's not always easy to stop it if it isn't going your way. I mean, sure, you got non-suits and stuff like that, but there are numerous situations where they can counterclaim and you can't get out of the case. The take-home message from what we do is we advise our clients what the likely cost is going to be, what the risk is that they might end up paying the other side's legal fees, what the upside is, what the potential downside is, and then ask the question, how important is it? And is it something that's, a base thing that the association feels they have to enforce to maintain their ability to maintain the community, architectural controls or rules or whatever? That having been said, we were involved in the Lees Hill case, and Judge Horn in Loudoun County went the opposite way from Fairfax County. Judge Horn said you didn't have to have it in the recorded documents. The board had broad authority to implement rules, and the declarant had the right to make unilateral changes to the declaration, which some of the homeowners there didn't like particularly, but it was enough so that the Supreme Court upheld the association's rulings. So I'm not as pessimistic as everyone else about where the Supreme Court will go. I do think there are one or two people on the Virginia Supreme Court who don't think that the homeowners associations have the power to do anything if it isn't in black and white. But I don't know that that particular view will be maintained over the years. I think that, and I'm going beyond your question, I think that the first two cases, Manchester Oaks and Belhaven, I won't say that the Supreme Court made a mistake, but I'll certainly say I don't agree with them. The other two cases, I have less problem with. Lees Hill ruled in favor of the association. The Shadowwood case, you got a horizontal property act with specific language limiting what you could assess for. Most associations don't have that language. So if you had a good set of documents, I'm not sure you'd get that result. The two take-home messages, and this is a little bit new. One is, it is more important than ever to look at your governing documents, work with your lawyers, and update your documents. If you don't have the authority to do what you want to do, amend your documents. And everybody says, oh, that's terrible, we can't do it, it's so hard. I've been involved in cases where we need 100% consent. If you need it, if it's important enough, you can get it. The second take-home message is it used to be, well, you better be careful who you buy from. That developer may not be a good guy. You know, that this could be a bad project, you could have no reserves, you'd have assessments go way up, and that was your big risk. Well, today, the risk is different. You could have 2 or 3 dissident homeowners, kind of like the ones in Belhaven, or the 4 or 5 dissident homeowners at Lees Hill. I'm sorry, Lees Crossing. Lees Crossing. Who bring litigation. In that case, they brought 4 pieces of litigation in Lees Crossing. The legal fees in that to the association were over $1 million. That community has the money to assess, collect, and pay the legal fees. The homeowner who lost doesn't have the money to pay the legal fees that the courts may assess against them. So what is the association to do? So the risk these days is you got to watch what your neighbors are doing, because they can bankrupt your association.
Next question is for Bill Mason. If an association does not have so-called self-help measures spelled out specifically in their governing documents, can they still implement self-help if they follow due process, was the question.
I don't think they can. I just finished watching a special, the Hatfields and McCoys, and I have to remind myself that this is Virginia. And self-help means, let's think about this for a minute. The shutters are not a conforming color. So you're going to go up on a ladder and paint the shutters blue instead of green, and here comes this guy in the driveway, right? I'd be nervous about that. In fact, we talk about self-help. We think it's good when the property's abandoned or it's vacant, or they say, we've actually had one case where we replaced a garage door and the guy was like, yeah, hey, how you doing? And I thought that was strange, but I think actually self-help actually runs, in my eyes, against the idea in Virginia that don't step on my land. So I think that's even more sacrosanct.
Especially Virginia being an open carry state, I guess it's not a wise idea to
By the way,
paint anybody's shutters.
I just wanted to add one thing. Someone asked, what's the point of having the due process hearing if you can't suspend and you can't charge? Well, I know there are all the risks, but don't forget you probably can go to court and seek a judgment. And we are working as a group to make it so that you can go to the lower court and it's less expensive and less timely. But there's some value. I think the real L in this, the real loss, is that it's an opportunity for the board to sit down with its neighbors without us here, there. And that's what was really lost. So you can have the hearing, you might get it resolved if they show up. But you can always say, we're going to decide if you're in violation, and if so, we may take legal action. We'll take legal action.
Just a real quick follow-up. Is it necessary to have due process to go to court to get injunctive relief on it?
I don't, unless your documents say that you have to do that, there's nothing in the courts that require that. I will say that it gets a little mileage with the judge that you try to work this out.
Yeah, they prefer you work things out to seek injunctive relief. Injunctive relief meaning go in the court to make the court have a homeowner do something or stop doing something, if that's accurate. So.
Tom, for the last 20 some odd years, we put a due process requirement right into the recorded documents because it's the right thing to do between the association and their neighbors.
If you're
Agreed.
blessed with a set of Bob Diamond documents.
Exactly.
That's
You
right.
may not be blessed with a set of Bob Diamond.
And we trust that future sets of documents will contain said finding authority, I hope.
It is,
So-
it is,
It does play a role.
it is a blessing.
Thank you.
Keep going, you're good.
Just one clarification. When you're talking about you can amend the document, what's the difference between, amending the declaration and the bylaws? Am I correct that it's insufficient to amend your bylaws, that you have to go to the declaration, and would you explain the procedure, which is more cumbersome when you amend your declaration?
Right. It depends on whether it's a condo or an HOA. It depends also what.
It's an HOA.
Well, it depends on where the provision is. If each document, each set of documents should have an amendment provision, whether they're diamond documents or other documents. And those documents will set out exactly what needs to be done with respect to the amendments, and also whether or not the area you're talking about is in the bylaws or is it in the declaration. In most instances, it's going to be the recorded documents in a POA, so it's going to be the declaration. In the condo, it's going to be most likely the bylaws.
Okay, we're going to press on here for a moment. Next question is going to go to Alan.
There you go, man.
Given the Shadowwood case ruling, Alan, given the Given the Shadowwood case ruling, how aggressive should associations be in collecting past due violation fines that have been assessed?
Charges. The other act.
Charges. What did I say? Whatever.
Well,
It doesn't matter anymore. It's the Nietzsche school of property management. It just doesn't matter.
Well, my view is that, we've seen how the courts have been strictly construing provisions of the statute and governing documents in favor of the homeowner and against associations, construing them very conservatively. And I think, frankly, in a lot of instances, unless you have express authority in your recorded covenants to assess violation charges or to adopt rules to assess violation charges, then I think you're probably throwing good money after bad to go into court to try to collect violation charges. And also, you may have trouble finding a lawyer willing to file suit for those violation charges, because lawyers get to deal with the fun federal law called the Fair Debt Collection Practices Act.
Right.
At the worst F word, the Fair Debt Collection
Right.
Practices Act. So there's two prongs, throwing good money after bad in light of these decisions, and also the issues with federal law preventing collection of debt that is not expressly authorized by contract or statute.
Okay, all right. P, you can take the next one. And then aside from amending the association's documents or filing an action in court, do you have any recommendations to our group concerning how to enforce rules, particularly architectural standards, in associations whose documents do not provide this express authority?
It was for me?
Yep.
Oh. Cousin Guido?
Cardinal can do that.
Oh, Patrick. He's in charge of human resources.
We are uniquely qualified.
Bring in Cousin Guido. Let the beatings begin. Well, as Bill Mason alluded to, the lawyers around this table are working together to craft solutions, and one of those is to modify a statutory provision that we were successful through primarily the efforts of Bill Maher several years ago to model after what the counties can do. The localities can go into court at the general district court level and seek payment of zoning violation charges, and also ask the general district court at the same time to order that the condition be corrected or the behavior to stop. It's a very useful tool. Otherwise, we are destined to head to the big boy court, which is circuit court, which is where the legal fees can rack up. Now, the way the statute was amended several years ago would give us authority to go into general district court after a due process hearing. And this past session, we did advocate for the introduction of legislation to try and untie the due process procedure from this general district court authority. We weren't successful, but we're hopeful to try that again. So we think if we can try and resolve it at the lowest level, which is the general district court, it could be helpful. The big travesty, and Bill Mason alluded to it, is that what the court has done is take away an alternative dispute resolution mechanism that was a really effective one, which I think Juan may have mentioned, brought people to the table, brought the conversation to a lowest level to try and resolve the dispute, for people to sit down across the table and talk to each other and try and resolve the dispute. Because many times, these architectural violations, there's another issue. These ones that get hairy and crazy, there's something else going on. There's typically a backstory. We always like the backstory, don't we? There's something else going on. There's either a neighbor-to-neighbor issue, or there is someone who can't take care of their property, or there's a monetary issue. So, you know, that sounds rather touchy-feely, but really it should be resolved at the lowest common denominator. And what the court has said is, no, you gotta suit up, get yourself a lawyer, and then let's go shoot him out in the OK Corral. Right. At court. And so there's no good solution. But I will say, the lawyers, we have this group called the Lawyers Breakfast Group. That should scare you. We sit around the table, nosh bagels, and drink a lot of coffee. And we just sat around the table this morning to talk about what we're going to do, what's the best avenue. And what is remarkable about this group is that it's not about us. It's about you. It's about how to help you keep from coming to us. I know that sounds really not self-serving and selfless for lawyers, but it's true. We're trying to figure out a way to help you. And we've gotten ourselves into this pickle to some extent by being pretty aggressive for you. Bob said it, Bob Diamond said it, we've got to renew the focus on the documents. We have always said you got to go check your documents. Well, now even more so, we need to do it. So that's a long-winded answer, sorry.
All right. Did you have a follow-up, Shirley?
Yeah, follow on. Yeah. If the court holds the due process hearing with the homeowner doesn't work out, homeowners do not agree to correct the violation, would you actually advise the board to assess a monetary charge knowing you're not going to be able to collect it?
If you don't have the authority, I wouldn't be assessing a charge. I'd probably have the due process hearing to try and resolve it, but if it doesn't, I wouldn't. You're left no alternative. And I'd be real clear with them. Look, folks, we tried to resolve it. We can't. We've got to enforce the covenants and restrictions, and we're going to have to do what we have to do.
Let me just add something, and that is, most of the folks here, you're dealing with residents of Fairfax, Arlington, but some of you may be dealing with communities further out. And there are some other opinions about communities further out. In Loudoun County, you've heard about the Lee's Crossing case. So you've got an opinion there that says you can assess those charges if you got a due process resolution. I shared earlier today an email with Pia from an practicing attorney down in the Charlottesville area, and he feels very strongly you can assess charges for violations consistent with Danone and a couple of other Virginia cases. So it's not uniform. So you may feel the pressure when you're dealing with your communities. Well, other lawyers say we can do it, or this case says we can do it, and we're not in Fairfax. So I think it's something you have to be careful of and be aware of before you just sort of say blanket yes or blanket no, okay? That's the state of the art right now.
One of the things that I want to reiterate what Pia and what Bill said. When I get a case and they ask me to litigate it, no one went to judge school to work on whether the deck is antique white or natural. That's not why they wanted to be judges. So the more opportunity you can have to paper the file to say, Judge, we have done everything in our power to bring this person into compliance with the governing documents, and we failed. We need your help. You're going to be in a much better place. So if it means to do the due process, do the due process. It makes all the sense in the world for everything that's already been said. But it also makes my life easier when I get the case and I have to litigate it, because then there's a good chance that we will get the relief you want and also the attorney's fees. Bob and I did a case not that long ago. He was my expert witness on attorney's fees, and we ended up getting the association every nickel because we had papered the file.
Yeah, there's one other concern I have based on what the conversations have been so far this evening, and that is, please don't mishear what's being said. There is a distinction between the courts in Loudoun and the courts in Fairfax on whether or not you have to have black and white authority in your documents before you can do things to homeowners, whether that's take away their pool pass, charge them fees, or whatever. But no one is saying you can't do that if it's in your documents. Anyone who has documents that have been written in the last, 15, 20 years, you most likely have that authority. So don't mishear us. You can do it if your documents allow it.
But the older ones might have limited authority, such as a suspension of right to use recreational facilities. So that still means you can take away the pool pass. So some of the 55, 513, et cetera, remedies were were also in the documents. They just didn't give you perhaps the power to take away the parking space. So we'll repeat what has been said multiple times. You have to look at your documents to see what is the nature and extent of your power to have those self-help remedies.
If I could, one other suggestion, and that's mediation. If you can get the parties to the table to talk, mediation. It is both parties, both sides, the association and the homeowner have to agree, typically share the costs, but mediation is a great way to resolve disputes. And there are some excellent mediation services, and through the Department of Professional and Occupational Regulation, the Common Interest Community Board, you can they will refer you to even internal mediation services within the agency. So you should consider mediation, but the big hurdle is agreement. That's the first step. You've got to get both parties. And as Drew described, and I'll pass it back to you in a second, Bob. Bob trained me well, so once I get the mic, I don't give it back to him.
You're both going to be banned here in a minute.
Yeah, that's right. As Drew said, it's an effort, and if you show that you've attempted to mediate, the courts like to see it. So back to Bob.
And that actually just answered another one of these questions on the card, so I can put that here.
Actually had a number of successful mediations in cases where I never imagined that I would be able to be successful, but thought in good faith I would demonstrate our good faith and put us in a good position prior to filing in circuit court, and lo and behold, we arrived at a settlement.
All right, I'm going to try a couple questions.
Well, this one I got to pick up.
No.
Got to pick this up. That's right. Pia mentioned that for mediation you need to have agreement. Well, at the risk of people here at this table disagreeing with me vehemently, we have been drafting a provision now in documents that, first of all, requires the parties to talk to each other. If that doesn't work, it doesn't give them the choice. It requires them to mediate. And in fact, if the mediation doesn't work, it requires them to arbitrate. So they can never go to court. Doesn't make the litigators happy, but they can never go to court. And about 50% of the developers who ask me to draft documents say, okay, put that in. 50% of them say, no, please leave that out. So again, it's imperative. You've got to look at what your documents say.
Okay, thank you. All right, we're going to try a question from a particularly different area here to see how this goes. I've got a question here that said, I'm going to give this to Juan. We have been told that we cannot post age restrictions at our swimming pool. That, for example, restrictions must be based on a skills assessment rather than age. Why is it not possible to restrict, for example, a 10-year-old child from entering our facility alone? What is this based upon, and what do you recommend associations do that have legitimate concerns about safety and orderly conduct at their facilities?
There are some cases where HUD has taken a very aggressive position in connection with enforcement of these anti-discriminatory laws. But I think the litmus test is the rule reasonable? Does it have a policy justification? I believe these rules that require youngsters to be accompanied by adults are reasonable. I tell clients to stick with them, and we roll with those rules. There are some rules that probably need to be revisited in light of some recent case law developments, one of which is this common practice of community association pools to enforce breaks that require children to get out of the pool while adults utilize the pools. Those are rules that HUD has historically taken the position are discriminatory because there may be children who are capable of swimming just as well as an adult. And so,
or better in some cases.
Or better in some cases. So one common course of action is for the owner of the pool or the operator of the pool to create a lap lane for people who want to swim laps, and that's typically going to be an adult during a lap period that's set aside for that particular use.
Okay, great. Next question for Alan. Does a lien automatically get extinguished in a bankruptcy, or can it remain in place and be settled whenever an eventual sale occurs?
The short answer is that the unpaid lien survives in most cases, particularly if you've got a Chapter 7 bankruptcy case, no asset. It usually takes maybe 3 months to go from beginning to end. And while the bankruptcy will discharge the owner's personal obligation to pay the debt, the assessment lien, if you filed one before they filed bankruptcy, will survive the bankruptcy and can still be enforced through a judicial or non-judicial foreclosure action as long as that action is taken within 36 months of the lien being recorded. So just because a debtor files bankruptcy doesn't necessarily mean that you're absent a remedy.
Okay, excellent. Next question is for Lori. Any suggestions on how to collect monies from a title company, besides a demand letter, who did not collect from the seller what was disclosed at settlement and for a Virginia deferred resale document?
Let me understand the facts. Was there a resale disclosure document
There was a resale
provided?
disclosure made to the purchaser that there were, or to the seller, that there were monies owed on the account. The transaction went to settlement without those monies being collected.
Now that also, there are two possible scenarios about how to collect that. First, if you happen to have wonderful documents that provide for what's called joint and several liability of the purchaser and the seller for assessments that are unpaid as of the date of the settlement, then the purchaser actually has personal liability for the unpaid assessments that were not paid at the closing on behalf of the seller. But if that is not in your documents, then you could file a lien against the property of the purchaser, even though, again, this is going to depend on what's in the documents, but let's say you've got a continuing lien, there was no foreclosure, you just had a voluntary conveyance, then if your documents don't allow for personal liability, then you can, as I said, file a lien against the property and pursue that through a judicial or non-judicial foreclosure as may be appropriate.
I'm not sure under that factual scenario that the original lien would be extinguished by the conveyance.
Oh, no, I did.
It was conveyance and the settlement agent didn't pay out.
There wasn't necessarily a lien on the property.
Oh, there was not? Oh, I'm
Not
sorry.
necessarily a lien.
Yeah, that's why I
It
asked
could be
for
a
the
small amount
facts,
owed,
'cause-
it could be the amount of the resale document itself.
Well, certainly if there were a lien recorded prior
Right.
to closing,
Right.
chances are the title company would have probably picked it up, and the scenario that you describe happens more likely than not when one isn't actually
I
recorded.
think this question may have come from some of my accounting staff. What we see happen is occasionally title companies just don't collect the right amount of money. And so they go to closing, they don't collect the monies that they're supposed to collect, and then it's like, well, who shot John? Do we go to the purchaser? Do we go to the seller? Is there a recourse to the title agent?
Sometimes informally, because a lot of times you can call up the title company, make them aware of the mistake, and the title company has a reputation to protect.
Right.
And a lot of times the title company will realize the mistake and correct it. But also with respect to the resale fees, remember that the statute specifically says that if the resale fees aren't paid at settlement or within 90 days of settlement, then you can assess those unpaid resale fees against the then current owner. So you remember that.
Okay.
You know, our experience, we just had a case like that, and we did do a judicial foreclosure, and it does get everybody kind of worked up, but one way of going, I don't think you have a relationship with the settlement agent, but let's say you take the course Lori's saying, put the lien on there. Okay, so now you're selling the new buyer's property. Well, they're all upset, so they make a claim on their title insurance. And the title insurance company says, well, we're going to go back to our agent, settlement agent.
Right.
So it takes a while, and it gets everybody all worked up, but you can get back to the
You
settlement
can't
agent
circle
that
back
way.
around, right?
I have had success in approaching the settlement agent, as Bill has described.
Yeah, what you have to have is the paper trail showing that you've had direct communication with that settlement agent about the arrearage. In some cases, that settlement agent is not getting a copy of that resale certificate, so they might not know. So that's why you have to have the hard copy of the email showing, hey, we reported the arrearage to you for collection purposes of settlement.
Okay. All right. So I'm going to read this next question, and you guys can decide who wants to take it. How about that? Prior to hiring Cardinal Management Group, our association was with a large, nationally based, name withheld, management firm. We found out afterwards that this company had been contracting various services with businesses that it owns or has an ownership in. In our case, our master insurance policy, among other things. To make matters worse, we found out the insurance did not even comply with our governing documents. No disclosures were made to our board about this, and in fact, we believe we were intentionally steered or misled in this direction and in the direction of other vendors. As an attorney, what is your opinion of this practice, and how can it be stopped in the future?
I'll give this one to Bob Donovan.
5 minutes or less.
Aren't you glad you invited me? Look, that is not a hypothetical situation. It's going on today. And we have a few large national management companies. We all know that homeowners don't like to pay large management fees. So management companies over the years have developed ways of getting ancillary income, which is usually the sole source of their profit. This particular company has gone, I would say, to the extreme. And how do you avoid that? Well, there's 3 ways. First, the board should be asking a whole lot of questions of their management company. Who do you hire? Do you hire anybody who's related to you? Do you get any kickbacks? Do you make any money off this? And sometimes that's okay if you're getting good service from one of their affiliates. There's a management company in Florida who actually makes a significant amount of money providing landscaping services, maintenance services, roofing services. But guess what? They're also a very cost-effective and very quality company. There's nothing wrong with that. What's wrong is when they don't tell you that they're related to the management company, or they don't provide insurance which complies with your governing documents. And that's one way, is the board's got to be sensitive to this issue. A second way is that when you find out about it, report it to the state agency that licenses the manager, and they could lose their license. Report it to CAI if it's somebody who's got one of the CAI designations, because they have a code of ethics that prohibits that. And then third of all, you've heard this before tonight, look at your documents. Every set of documents that I write now says that the management company cannot accept any money, remuneration, kickback, benefit, or anything related to that for services provided to an association they manage without the informed consent of the board. So if they're doing it, they're violating your documents. You can also put it in their management contract. If they do it, they're violating their management contract, and you can fire them. So yeah, there's ways you can protect yourself, but yeah, you got to know about it. You got to know that management companies, some management companies do that. And talk to your lawyer, make sure that they take a look and see if some of these guys are related. But, you know, there are bad guys in every industry, and some people are doing it the right way, some people do it the wrong way.
Of course, the problem with all that is if a lawyer does it, you get disbarred. If a management company does it, they just move on to the next stooge. That's what ends up happening. So you have to be very careful about that and and have your management company be transparent.
If everybody doesn't hire them, they don't last long.
That's right, yeah. Okay. This one I'll give to Lori. Our management company collects assessments for our association. Is the association subject to the Fair Debt Collections Act that we hear so much about?
Well, you use the term association, and
That's the way
the
it's written.
association is not necessarily subject to Fair Debt Collection Practices Act. So let's say if you were a self-managed association and your board treasurer sends out a letter, that board treasurer is not subject to Fair Debt Collection Practices Act. We as lawyers are absolutely subject to Fair Debt Collection Practices Act, and the question is, are managers subject to Fair Debt Collection Practices Act? And there have been some federal cases that say, no, they are not. But the test is, from what I recall, and if any of you want to add anything to this, but my understanding of the test is that if the manager is so closely related in the collection activity to the work of the association. I mean, in other words, if the manager and the association are one and the same when it comes to the collection activity, then that manager is probably not subject to the act. But I would defer to your general counsel in advising you about how much risk you want to take. But from my understanding, there have been some federal court decisions that have said managers are not.
Okay, very good. Next question is for Pia, and we're going to move the answers along quickly. What actions has, in your capacity being on the CICB, what actions has the General Assembly taken this year to amend the laws that govern community associations that have a direct impact on the administration and governance of common interest communities.
That's not a long, not a short answer. But I do have with me.
Something on late fees, right?
Oh, like, I do. There's several, and I have I brought our checklist with you. We do a checklist of things that we recommend that you consider and look at your documents, as you see the persistent theme, about taking advantage of some of the changes in the law. There were a number of changes. There was one dealing with late fees, but subject to some discussion on its helpfulness, effective July 1. If your documents are silent on the issue of late fees, you may be able to take advantage of a statutory provision that was put in place. There's some changes on resale disclosure and association disclosure packets, some additional statements that you have to include in those. So management needs to look at your forms and update those. There's also a significant change on home businesses and the permissibility of conducting businesses in homes that you need to look at very carefully with counsel and your management agent, and again, your documents to determine what is and is not permissible. And if you're a developing condominium community, there may be some changes with respect to the enforcement of the warranty obligation that you ought to take a look at. But I did bring with me, Tom, our annual checklist, and I'll leave them here for anyone who would like it. But you ought to talk to council about those changes.
Okay. Yes. Sure, please.
Curious to know how many of you think that a late fee of $25 on a delinquent assessment or on a delinquent installment of an assessment is a reasonable amount. How many people think $25 is reasonable? Well, unless the payment of an assessment or installment is $500 or more, depending on what's in your documents, as of July 1st, it may not be permissible to charge that amount. So again, not to sound boring, but you're really going to have to look at your documents, because the way I see it, there are 3 different scenarios. If your documents are completely silent, then there is the default of the new statute going forward July 1st. If your documents mention the word late fees but don't have any specific terms, then I believe that it's probably going to be permissible to adopt rules and regulations, to adopt terms, to specify late fees. In other words, you may not want to wait 60 days. So if your declaration to charge late fees, and you may not want to only charge 5%. So if your documents say that you're allowed to charge late fees, then I think it's appropriate to adopt rules. And then you've got the other scenario where your documents specifically have provisions in them, then you have to go along with those, whether they're more or less favorable than the statute.
Okay, great. All right, yes, sir.
It seems to me that changing the laws is making it harder for the board members to do their job.
You bet.
Yes, it is.
It makes it harder for the lawyers to do their job, because now every time going forward, July 1st, every time I'm asked to collect a delinquent account, I have to go back and review the authority for late fees. And this is huge.
It is huge, and the bad part about it is, as a board member, you work for free. As managers, we work almost for free, and these guys get paid for the hour, by the hour.
You know, we've said about 6 times.
Yeah, that's right.
You've heard about 90 times tonight, look at your documents. Well, the next thing you do when you get finished looking at your documents is go talk to your state legislator and tell them to get out of your face.
Amen. They keep doing this, not just to the lawyers, but to the managers, but to you as homeowners. I mean, you know, law is supposed to evolve, and the way I see it, things are devolving. It's becoming more and more difficult to do things effectively and efficiently. And, you know, we get a lot of pushback from the clients about, why can't you help us? Why can't you do this? And a lot of times we're hogtied. Yes, sir.
In the read your documents, when we do read our documents, and we're looking for the
violation, what should we read in terms of the text? What should it say so that we know we found it or not found it?
Well, I think it depends on what it is you are looking to accomplish. I mean, for example, if you want to suspend somebody's right to park on the common area, you're going to have to, no, don't, but you're going to have some very specific language authorizing you that's not going to contradict. I mean, let's say you have authority, you're an HOA, and I keep saying 55-513B, but if the documents say that, yes, you have the authority to take advantage of the remedies that are prescribed by either the POA Act or the Condominium Act, and you do have those remedies, well, with parking, perhaps, maybe that's not the best example, but you may want to make sure that taking away parking doesn't contradict some other provision of the document. That's just one example.
Taking money.
Yeah.
Let me be blunt about it. In documents done in the last 20 or 25 years, this will not be subtle. It'll say, if you don't pay, you pay a $25 late fee or such other amount as the board may determine. If you violate the rules or you don't pay, the board can suspend your voting rights, suspend your right to get the pool pass, da-da-da-da-da-da. It's there, it's clear, you won't have trouble finding it.
I have one question that I promised the client that I would ask, and I'm going to give this to Drew because it has to do with parking. This association has for has for years had an assigned parking scheme that worked reasonably well in the community. Each unit is assigned one space, and it was designed by the board of directors and a parking committee. Occasionally, owners have challenged the system either because they want additional parking or they want a space in a different location. So 2 questions. Under recent cases, what do you recommend they do? Should they wait until someone sues or dismantle the system now? And then as a follow-up, if the boards are prohibited from assigning a space in a common area parking lot to an owner, how does it impact the association's ability to make such assignments when a handicapped owner or resident requests a reasonable accommodation of an assigned spot close to their homes?
In the answer to the first question, it really, to reiterate what my good friend Bob Diamond says, it really depends upon what your governing documents say. But most likely under White, under Sully Station, and under Manchester Oaks, the right to assign parking spaces, unless it's absolutely unambiguously clear in the governing documents, is not going to happen. You're not going to be able to do it. You know, that's just the way it is. And even if you only have 1.5 parking spaces per lot or per unit, you're going to be stuck. And you're going to have people are going to be annoyed by it, but, you know, thank Bill Mims. As far as the second part is the Fair Housing Act, if you're talking about common element parking spaces, then the person is entitled to a reasonable accommodation, and the courts have ruled that that is a reasonable accommodation to assign a common element parking space to an individual with a disability. So that would be in compliance with the Fair Housing Act, which is a federal statute which would trump the state law, so I think you'd have to go along with it. Now, if it's a limited common element, we just finished a case in Arlington, and the court basically said no, because that's an ownership, especially if the limited common element's been conveyed to the unit owners, then there is a whole murky issue there, but most likely that would not have to be conveyed.
Don?
How does that reflect the number of cars per unit? Is it an infinite number of cars? If I have a situation where I'm in a row of townhouses, got 12 parking spaces, one owner's got 12 cars.
The way Mims has written it in Manchester Oaks, I think the 12 cars, unless you amend your governing documents, because, and that might...
Again, I tend to be the outlier here. If you've got currently drafted documents that provide power in the board to regulate the use of the common elements, it specifically, in all my documents, provides something called reserved common elements, which allows specifically the board to take pieces of the common elements and say, you can use it. You got stuff in your documents, I think you can do that all day long. You can say no more than 2 cars on the common element parking, you could do all that kind of stuff. You gotta look at your documents.
A little dissension on the team here, so.
Bob, that's most likely condominium documents, not POA documents. Well, in some POA documents, it really depends upon your governing documents. I mean, Bob's point's well taken, but in most governing documents, if it is silent, then the 12 cars can go and you're going to have to amend. If there is that provision, then there may be a way out.
So it goes into even further, the cars don't have to be currently licensed, they have to be in state, they don't have to be, they can be on blocks, they can.
It depends on the
So-
documents.
Right.
No, the documents always have provisions, yeah. If those provisions, and if they have junk vehicles and things of that nature, 99.
I understand that part.
Most declarations of covenants are going to specifically give the board the authority to adopt reasonable rules regarding the use of the common area. And I don't see any of the court cases that we're talking about tonight to prohibit the board from by treating everyone equally and issuing one parking pass per lot.
That's an interesting twist. All right, I'm going to move on to another matter. Bill, why don't you take this one? The question is this. A couple of years ago, our association was subject to a so-called administrative action when a resident filed a complaint with the County Human Rights Commission claiming they had been discriminated against because of their national origin. The board was attempting to enforce a restriction about smoking in the common area hallways. This was a frivolous and expensive process for the association. Is there any way an association can fight back in situations like this? For example, in litigation, you have mentioned cases where the prevailing party has the right to collect its attorney's fees. Is there anything similar to this in administrative actions?
First of all, I think there's a difference between regulating smoking in the common elements of the lobbies and the unit. I think there's authority, or could be authority in the documents for the common elements in the lobby. The gray area is the unit, and where someone in the adjacent unit smells smoke. I have a difficult time finding where under fair housing that someone smoking is in a protected class.
Well, in this particular case, the individual claimed that he was being singled out because of his religion, and that it's in his culture, smoking is something that's embraced. I think you probably know the case I'm talking about. So it ended up at the Fairfax County Human Rights Commission. The association was remanded to take sensitivity training. We had document productions. I mean, there was a lot of stuff that went into it. So I think the question is, and I may know the answer, there really isn't much that the association can do to push back in situations like this.
What you absolutely want to avoid doing is doing anything that seems like you're retaliating.
Oh, sure, of course. Right.
Yeah, I mean, the danger about fair housing is that the associations are really sued by law firms that work only for their attorney fees, and they're huge law firms and can rack up several $100,000 very quickly. And so I think Alan's point is well taken. I mean, you want to treat this with kid gloves to try and get this diffused
as soon as possible, right?
I just one additional comment, Tom, and that's where I think the issue of take a look at what kind of insurance coverage you've got. We've been involved in a couple of these, and they get very expensive very quickly. But you want to notify your carrier right away to see whether or not there may be coverage for the defense of those kind of claims. They get very expensive, and then all of a sudden a plaintiff complainant walks away from something where there's a finding, and you're sitting there with lots of attorney's fees and no recourse. And so it's something that you need to at least be aware of what your insurance coverage might be in that case.
Right. Okay.
One additional important point about that, which people who are not at this table are not going to want to hear, and that is, yes, it's very easy to tender to your insurance company. And some of the folks around here actually work for the insurance companies representing associations. But if you are an association and you're in one of those situations, you better evaluate the attorney that's being provided by your insurance company. Some of them are excellent. Some of them are not going to do a very good job of representing you, and if they don't, your insurance carrier may come along and say, you need to settle this case, and by the way, it's more than your coverage amount. So you have to always evaluate who is representing you, whether it's insurance carrier counsel or your normal association counsel.
I do have to defend the insurance defense industry. We don't represent the insurance company, ever. We always represent the association, and even if you don't do general counsel work on a constant basis, the individual, the firm that is assigned to the defendant is representing the association, and the attorney-client relationship is between them, not the insurance company. No. There's good ones and there's bad ones, just like everything.
This is a question of a different color, and we're going to try to get a couple more in, and we're going to wrap it up for tonight. Let's see here. Here's one. We have a board member who believes the association should purchase iPads or other tablet devices for its board members to use in the conduct of their roles as directors. Can this be considered a reasonable association expense, and is it appropriate?
That's got Juan Cardenas all over it.
You know, I do get asked questions like that with some frequency, and it really is going to depend upon the expense and whether you can, as a board member, withstand the criticism that you're going to get from the membership if they find out about that expense. Most of those disputes never see the inside of a courtroom. It's all resolved at board meetings, with boards taking criticism for the expenses that they incur to feed themselves at a board meeting and do things of that nature. We have several clients that put on a party for the board once a year. They provide food at board meetings. There are some nominal expenses. I'm not prepared to say where that line is, but I think there are some incidental expenses that the board can authorize for the facilitation of business by the board. Obviously, at some point, it gets excessive. You're going to be subject to hyper-criticism. It's not worth it to get into that place with your membership. So obviously, a lot of caution is to be exercised. I'd like to know what is the expense of these devices. What are they going to be used for? Will they remain with the association, or are these board members going to take them and use them for personal use? Obviously, that stuff is not right. It's beyond the authority of the board to approve. I don't think there's any black and white on those issues, a lot of gray. Most of us know where the line is. And
It walks like a duck, right?
yeah, and I think you gotta draw it in deference to your critics. You gotta be purer than the wife of Caesar.
Right, okay. All right, so I think we're going to wrap it up. It's 9 p.m. I'm going to ask one more question. I'm going to lay it out there for the panel to answer. I think it kind of draws a nice point on what we've been discussing this evening. And that is, given that many recent court cases in Virginia impose restrictions on the way that common interest community associations operate, do you foresee this trend continuing? Are judges reacting to political pressure to diminish the power of homeowners associations?
Yeah, I'd like to just start with an anecdote. I was meeting with a board in Stafford County, and we were reviewing some of these cases. And I was giving them all the bad news, and there was a board member who told me he was involved in a legal dispute with his country club. He got ejected because he wasn't wearing the right shirt. He fought the ejection. They suspended him. They added charges to his account. This guy got ticked off. He filed suit in Stafford County. Court ruled in favor of the country club. Documentation to support the position of the board of the country club was thin to non-existent. I didn't review the file. I'm relying upon what the guy told me, but I found it fascinating that the country club had all of these powers that community associations do not have, according to the judiciary. There's really something going on with the community association marketplace that it's very difficult to explain. We're involved in a mandatory membership organization. The judiciary does not seem to think that the transaction of somebody becoming a member of an association is entirely volitional in comparison to somebody who joins a country club, and that's totally voluntary as the judiciary sees it. And so since there is this perception that our membership is not subscribing in a totally voluntary way to the rules, the courts are construing the powers of community associations very narrowly. And I think that's one of my takeaways about what I'm observing in the marketplace in the last 12 months.
Okay, thank you. Any other comments on this?
Well,
Wait a
just
minute.
another thing from personal experience as well, just even talking to some of the judges. The judges, especially the judges in Northern Virginia, live in communities, and some of them may not be well managed, and some of them may have caused the judges in those communities to form impressions of communities that were not entirely flattering. And well, I mean, we don't have enough time for me to share a story about a judge who shall remain nameless who had, this is many years ago, this was the last time I accepted a case in which I represented an individual against an association, and one firm might even know about this, but the judge was not the nominal party, but the judge asked me to represent his neighbor who was the nominal party, and I learned a lot about what the judge's perception was of about community associations. And so I think we as attorneys really need to endeavor to educate, and to the credit of a few years ago, but a relatively new judge in the Fairfax General District Court who, upon taking the bench, had never practiced civil law and actually asked me a lot of information about community associations, and I was very happy to oblige.
Well, three things that need to be said. The first one is everything is relative. Virginia is in the middle. If you look at California and Florida, that is where you really have legislative micromanagement. You almost cannot hold a board meeting without a lawyer because there are so many sections of the California and Florida law that affect everything you do and how you do it and when you do it. And what you can't do, you got to have a lawyer. Virginia is much better than that. Now, are we going in the wrong direction? Yes, we are. But the second point that needs to be made, and this is in response to Juan, the reason that judges make a significant distinction between places like golf courses or country clubs and community associations is because you don't live at a country club. People's homes are different emotionally than belonging to a country club. Some people may care about their, ninth green or whatever, but it's not quite the same as to where you come home every night and how you get treated by your neighbors. Judges know that. There's a lot of emotional weight to that, and they just are not going to treat those situations the same. Oh, and last but not least, I forgot the third one. some associations are bad actors. They do bad things to their residents. Judges know that, so they, kind of look askance when the association tries to bear down on an individual homeowner.
I agree with you. I do see the trend continuing.
Bob and I were involved in a piece of litigation together, and we won everything in court, but the board clearly lost the PR war, at least with regards to the community. And I think that it behooves us as practitioners and as you all as board members. Pia started off the presentation talking about Old Bellhaven and the misconstruction in the Post, the misconstruction, my goodness, in Common Ground, which is a periodical in the industry. We've talked to senators and delegates in the General Assembly. They hear from the dissident unit owner, but they don't ever hear from the boards. So it would be very helpful for when there's a General Assembly's being elected this year. There's going to be people that are coming around looking for your votes. Say, hey, you guys are making it hard on us, and they're going to listen to you all as their constituents a whole lot more. Pia does a terrific job. Bill does a terrific job. Kenny Chadwick does a fantastic job down in Richmond. But they're going to listen to you, and you're going to say, you know what, that late fee provision that Lori Dolson just talked about, that thing's a royal pain in the neck. And all we're trying to do is collect for the poor soul who pays his assessment all the time. That's all we're trying to do. So we all have to work together and do a better job with public relations, because that taints the General Assembly. And who elects the judges? Those folks.
Yeah.
Yeah, Drew, I think you really hit it on the head. I think, and I'll just relay a quick story. I had a conversation last week from a local delegate who was seeking some support that I've gotten to know over the years, and he was talking about the situation in Richmond. He was talking about the situation with some of the cases we've been talking about, and a couple of his fellow delegates who sees some problems with in terms of the way the industry's going and being handled. And his point is people have to understand better what's going on. They have to have a better appreciation for the way associations are functioning. He has that, in large part because of a lot of things that PIA and the LAC and CAI have done. I mean, we are coming up on the silly season. Come Labor Day, all the delegates are up for election. They'll be holding sessions in communities or in rooms like this, and the owner's going to get up and say, I've got a problem with my association, and that delegate is going to say, I can fix that. I'll introduce something. And all of a sudden, and Peel can tell you, we'll look at 30, 40, we're coming on to a long season, 30, 40, 50 laws that could be affecting the way associations function. You've been asked, we will continue to ask you to help us educate your constituents, help you be better educated about some of these things coming up. It's an ongoing process, and as you've heard from the cases that have been decided, some of the laws that were passed, and Pia could go on and tell you about the laws that didn't get passed, and you talk about some silly things, she'll tell you about some of those. Time, effort, and money has to be spent. So it is an ongoing process. We're all in this thing together, and we got to work through it together.
And in the interest of time, I'll say what they said.
I won't.
I yield the floor.
Actually, I do subscribe to all of their views and share them, and would add one last impassioned request, that you do talk to your legislators. The trend is not good. It's not a good trend, but it can be stopped. I am hopeful. And the way to do that is to have a conversation, and we need to educate our legislators. We need to explain to them what you do for your community, for your homeowners, the services that you provide, the burdens that you take off of local governments, and the good that you do. It's often the bad that they see, and there's so many good things that communities do. And I'm not just talking about the stuff you have to do under your documents or the services that you're contractually obligated to provide. Your neighborhoods And those developers who've created you are dreamers who have tried to recreate the neighborhoods of old, where people sat on their porches and talked to each other and had a conversation. But I know it doesn't happen always. So what we have to do is we have to try to educate and explain to them that you have multi-million-dollar budgets, that you are a business in Virginia. You contribute to the tax base of these localities, and you provide important services that a local government no longer needs to provide. So what I would encourage you to do is, if you're interested in doing that, first of all, reach out to your local supervisor, reach out to your local member of the House of Delegates, your local senator, invite them to your association, tell them what you do, show them the good that you do, take them around the community, show them your beautiful facilities and park-like areas, the common areas that you maintain, the stormwater management that you do that takes that burden off of a local government. And I would encourage you to do something else. June 20th, if you have time, 10 o'clock, come talk to the Virginia Housing Commission. Let's start a dialogue, not asking them necessarily for something, but telling them what you do that's good. Let's turn this negativity to a very positive message. We lawyers tend to the bad. That's what we do. We are hired to tell you what you can't do. The creative part is finding a way to tell you what you can do. And what you can do is be agents of change with your legislators and in your communities. So I would encourage you to do that. And one last thing, thank you. Thank you for volunteering. Thank you for doing a thankless task that many people run and hide from, that creates personal liability for yourselves and which takes time from your business and your family. You are doing important work that those of us here at the table are all paid to do, and in the front row here at Cardinal Management and disperse some of the managers. Thank you to the volunteers, because you are doing important work, and work that is very thankless, but we appreciate it. And thank you, Tom, for doing this. This is a great opportunity. We love the Ask a Lawyers. You didn't really get a knockdown, drag out. We could have done that. It could have been staged. We're all WWF fans, so thank you.
We do UFC on the property management side. At WWE, that's fake. So in conclusion, ladies and gentlemen, I want to thank you for taking time away from your family and friends, and all of us have certainly more important things to do. Probably a television show some of us are missing. I don't know, but it's been our pleasure to have you here. This is what we do. Cardinal Management Group is dedicated to the service of our communities. We've got a great company with great people, great clients, and great colleagues, and I thank you all very much.